within the marrow of her bones, they find the best evidence to support the prosecution of Barry Morphew in this case, and they can't do anything about it. The man authorities have dubbed the Gilgo Beach Serial Killer learns that he will face 7 counts of murder, all in a single trial. Plus, a Colorado man accused in his wife's disappearance and murder gets a win. But will it matter? And attorneys challenge the death penalty in the case of a man accused of murdering a healthcare executive on a Manhattan sidewalk. All this and more this week on Courtroom Confidential. Another busy week, and we appreciate you choosing us to bring you the news. We are recording this episode on Friday, September 26, 2025, and this is your Courtroom Confidential weekly roundup. Let's jump in. A New York judge ruled Tuesday that accused Gilgo Beach serial killer Rex Heuermann will face a single trial on all 7 murder charges. Heuermann, a former Manhattan architect, was arrested in 2023 and has pled not guilty to the killings, which span nearly 2 decades. The victims include Sandra Castilla in 1993, Valerie Mack in 2000, Jessica Taylor in 2003, Maureen Brainerd Barnes in 2007, and Megan Waterman, Melissa Bartholomew, and Amberlynn Costello between 2009 and 2010. Heuermann's defense team sought to split the cases into multiple trials, with attorney Michael Brown arguing his client risked an improper conviction from the, quote, cumulative effect of the evidence. He also pointed to disparities in some of the deaths, including different timeframes, killing methods, and body disposal locations. Prosecutors countered that the victims are inextricably interwoven through geography, victimology, forensic evidence, and Heuermann's own planning document. Prosecutors said last week they are ready for trial and confirmed they have turned over evidence to the defense, including a 723-page inventory, a list of more than 7,000 people who may have evidence or information relevant to the charges or potential defense, and a list of expert witnesses. A major issue in pretrial hearings has been DNA evidence. Prosecutors say ties Heuermann to 6 victims. The samples were tested using whole genome sequencing, a method never before admitted in New York criminal trials. Judge Timothy Mazzei ruled earlier this month that this evidence will be admissible. The defense then argued the process violated state health laws, which bars for-profit labs from submitting evidence in criminal trials. But on Tuesday, Mazzei again denied that claim, clearing the way for the DNA to be used at trial. Heuermann will return to court in January. No trial date has yet been set. What's happening here? Well, appreciate what I'm about to say by understanding that I'm just talking about the arguments in this case. But the defense is making an excellent point. Their point is essentially this. You cannot take a case with several different counts, and they're all different. They're all different crime scenes. They've all been processed differently. They've all had perhaps even different investigators working them. And you can't package these all together if some of them are very strong and some of them are not so strong or even very weak, and then ask jurors to distinguish the evidence in all of those cases. Now, this is the defense argument. I'll reiterate again. They're saying that you can't take weak cases and bootstrap them to stronger cases. If a jury finds him guilty of 3 of these murders, well, they took a look at the remaining 4 that might be weak, might not have as much evidence, and say, well, you know what? If he did it 3 times, he probably did it the additional 4 times. And that, they say, would be impermissible. Think about it this way. It's the same arguments that we see in cases where we're talking about prior bad acts. Anytime you're trying to introduce evidence of other unrelated crimes, and if this at all has the effect of affecting how jurors view the charged crimes, that's a problem. We don't allow for conviction by character. We don't allow for somebody being convicted of a crime because, hey, well, we believe they committed a murder, and therefore a murderer probably commits other murders, and therefore I believe this man committed these other murders, though the evidence independent to each of those crimes is not all that convincing. Now, all of that being said, did the judge make the right call in this case? The answer is yes, because there's other things at play here. First of all, you're talking about several different crimes which are going to have many of the same witnesses, many of the same expert testimony, many of the same evidence, and you're also considering judicial economy. You cannot split these up into 7 different trials. This could go on for decades. So there is an interest, and we understand that, a public policy interest in having these all tried together, especially because they are the same overall criminal conduct. It's not like we're talking about trying to tie together a bank robbery case with a extortion case, or a bank robbery case with a kidnapping case that are unrelated victims, unrelated even consequences. We're talking about murders that all were conducted under similar means, in a similar time frame, their bodies disposed of in a similar geographic area, and therefore the judge, I think, did make the right call in this case. So what is the point in a case like this where the man accused is looking at a lifetime exposure on just one count of murder? What's the point in getting all bent out of shape of whether or not these crimes are tried together or not? You might be asking yourself. Well, we know, and it goes without saying, that justice applies equally to every defendant, no matter what they're charged with. But if you want to look at this from a more pragmatic and tangible reason, we don't want an overturned conviction in this case. We don't want this case coming back on appeal. We don't want to have to put these victims' families through this all over again 10 years down the line because it wasn't handled properly now. But what do you guys think? Do you think that this trial, 7 counts of murder, will ever see the light of day? Please let us know in the comments. Barry Morphew, the Colorado man accused of killing his wife Suzanne in 2020, was released from the Alamosa County Jail after supporters helped post a $300,000 towards his $3 million bond. Morphew's attorney, David Beller, told reporters that supporters of Morphew who covered the cost did not want their identities disclosed. Quote, "They have asked to remain anonymous," Beller said, "and that frankly is for their own safety with all the vitriol that the case has brought and all the doxing. As a condition of release, Morphew will be on strict house arrest with an ankle monitor. He must abstain from drugs and alcohol, surrender his passport, and if he can find employment, he must get court approval to leave home for work." Morphew was originally arrested for murdering his wife in 2021, but her body had not been found at that time, and the prosecution struggled to meet deadlines for producing evidence. The charges were eventually dropped before trial began, allowing for them to be refiled if new evidence emerged. Suzanne's body was then found in 2023 in Alamosa County, about an hour south of Morphew's home. An autopsy performed in 2024 found the presence of a unique mixture of animal tranquilizer chemicals that Barry Morphew was known to possess. A grand jury indicted Morphew on murder charges this year, and he was arrested in Arizona, living under the alias Lee Moore. The next hearing in the case is set for November 3rd. As for when the case could go to trial, attorneys said it would be next summer at the earliest. What's happening here? Well, the best thing that ever happened for the prosecution in this case is that they couldn't get their case together the first time around. I know that a lot of the blame for why that case was dismissed fell at the feet of the prosecution, that they simply weren't able to meet discovery obligations, they were running afoul of some of the rules, and they decided to dismiss the case. I think something else was also at play. Their case wasn't ready. This case was not ready to go to trial. Now, that's not to say that a no-body case is never ready for trial. Many of them are. Many of them are incredibly strong. You can put these cases together through circumstantial evidence, or even things like confessions or admissions or secret recordings, eyewitnesses. This case had none of that. This case was highly speculative and based upon circumstantial evidence, and it may have been a case that a good defense team could have had some arguments take traction, and they could have lost. Now think about that. Had they brought this to trial before Suzanne's body and her remains were discovered, and they lost, and he was acquitted, and then they find her body, and then within the marrow of her bones, they find the best evidence to support the prosecution of Barry Morphew in this case, and they can't do anything about it. That, to me, would have been a real tragedy. Were many people discouraged the first time around when the case was dismissed? Sure, but I think it was a blessing in disguise. Now, the defense has a small win in this case because he was recently allowed to be released on bail. The judge changed the conditions, not the amount of bail, but changed the conditions so that he was able to post bail in this case through anonymous supporters. That doesn't mean he's going to win. That doesn't mean the case is thrown into complete turmoil, but it is a win for the defense for many different reasons. As always, the defense controls the clock more than the prosecution. The defense can ask for more time. If the defense invokes their speedy trial rights, they can put pressure on the prosecution to have that case brought to trial earlier. So to some extent, the only thing that the defense really has an advantage in is in control of the clock. Well, when you have a defendant who's in custody, that's more difficult. Now you've got a person who's sitting in jail every single day awaiting this trial. Pushing it out for months might be something that they simply can't live with. So that's one advantage. Two, preparation, the ability, the ease of being able to meet defense attorney and defendant in privacy at their leisure, go over the evidence, talk about their strategies, not be in a lockup while that's happening, while they're possibly being recorded, while they're not allowed to hand documents freely to the client. That's a huge advantage. Then there's just things like your client being exhausted, the defendant being exhausted when they come to court every single day, when they go to trial. They wake them up at early morning hours, 4 o'clock in the morning, hand them a peanut butter and jelly sandwich and tell them you've got court all day. But there's some other benefits too, some things that we might not think about. Things like how will the jury, a potential jury, perceive him differently being in or out of custody? Now, when a defendant is brought in for trial, they're dressed down. A suit is put on them. But jurors can understand those things. They know this person's still in custody. They can tell they're wearing the same suit every day. They can tell they look exhausted. They can tell they never saw that person walk up the courtroom steps to get to court. I once had a trial where afterwards I spoke to jurors and they said they could easily tell that the defendant was in custody despite the fact that he was dressed out in a suit every single day because of his shoes. Those were jailhouse shoes. Will that have some small psychological effect on the jurors? In any case, this is a win. It's not going to change the outcome of the trial, but I will tell you now, time is on their side and expect this case to drag out. But what do you guys think? Do you think this is a big win for the defense, or really, in the grand scheme of things, it will not matter all that much? Please let us know in the comments. Lawyers for Luigi Mangione, accused of assassinating United Healthcare CEO Brian Thompson in December of 2024, are again asking a federal judge in New York to block the Justice Department from seeking the death penalty. In a 118-page motion filed over the weekend, Mangione's attorneys argue prosecutors are pursuing capital punishment for political reasons and that top officials have improperly discussed this case outside of court. Mangione, a 27-year-old former Ivy League student from Maryland, is accused of stalking Brian Thompson to New York City and fatally shooting him. Mangione was arrested 5 days later in Altoona, Pennsylvania. In this recent filing, his attorneys accused the Trump administration of using the case to push a political agenda on capital punishment, quote, to demonstrate its loathing of the prior administration, contrasting it with President Joe Biden's decision to clear 37 out of 40 inmates off of federal death row before leaving office. They also criticized Attorney General Pam Bondi, pointing to her April comments on Fox News, where she told viewers, quote, I was a capital prosecutor. I tried death penalty cases throughout my career. If there ever was a death case, this is one. The defense argued that such remarks prejudiced the case. The defense wants the federal indictment dismissed or at least to block prosecutors from pursuing the death penalty. On Wednesday, U.S. District Judge Margaret Garnett warned the Justice Department officials could face sanctions if they continue making public comments about the prosecution of Mangione. Garnett issued an order suggesting that statements by government officials about Mangione potentially facing the death penalty may have violated a local rule designed to limit publicity and ensure a fair trial. On the state level, a New York judge recently threw out terror charges brought by Manhattan DA Alvin Bragg, leaving Mangione facing at most second-degree murder. Thompson, age 50, a Minnesota father of two, was in New York for a shareholder conference when he was killed. Mangione has pled not guilty in state, federal, and Pennsylvania cases tied to the slaying and the 3D printed gun allegedly used. What's happening here? This is rare. This is rare for a federal judge in particular to come down on the prosecution in this kind of way. Federal judges are tough, notoriously so, but for them to call out the prosecution, issue a warning, essentially, in the form of an order saying, if I hear about this again, we're going to have problems. Appreciate that. The judge is not allowing this case to turn into some sort of political talking point, some sort of campaign point for the administration. And good for her. This is serious stuff. This is serious for the country, and it's serious for this defendant. The United States government is pursuing the death penalty against this man, and that should be taken seriously and not used for political points. And while the judge may have concerns over the public comments being made by the Department of Justice, I don't think any of it is going to change the judge's mind on allowing the feds to pursue the death penalty in this case. If the law is on the books, and the law is that murder charged under certain circumstances allows for the federal government to pursue the death penalty, there is nothing being argued by the defense at this point to undo that, in my view. Now, one last thing on this case. One thing I haven't really heard about, and I expect to hear about, is the defense attacking federal jurisdiction in this case to begin with. This case is being pursued by the federal government based upon stalking across state lines. Their theory is that Mangione hunted down Thompson across state lines. And by doing that, and then committing murder, it opens up for a federal prosecution in this case. There's room for argument there by the defense, in my view. There's room to say, listen, this wasn't about stalking. It was about meeting this person at a certain location where he knew he would be. He may have stalked him, if you want to take the definition of stalking at its most broad, within the state of New York by following him from his hotel to another location. But to say that he was stalking him by merely knowing where he was going to go and where he was going to end up, to me, has room for argument. Now, maybe we don't know everything about this case. Maybe there's more to it. Maybe the feds know more, and I hope that they do. But I would expect somewhere along the lines us to see a challenge to the federal jurisdiction in this case to begin with. But what do you guys think? Do you think this crime, no matter who is bringing the charges, the state or the feds, do you think this murder is worthy of the death penalty? Please let us know in the comments. Hey everyone, as you can tell, it has been a very busy week. But before we dive into the other cases that made headlines this week, I'm going to just pause for a moment and ask you to do me one very small favor, and that is to please subscribe to this channel now if you haven't already. We want to continue to provide you with the highest quality content that we possibly can, and the best way that we can do that is through your support. Also making headlines, the Utah man accused of fatally shooting a conservative activist during a campus speech earlier this month has now been assigned a defense attorney. The Utah County Commission approved the appointment of Catherine Nestor, a former federal public defender with more than 30 years of experience, to lead the 22-year-old Tyler Robinson's defense. This action fulfills the commission's constitutional responsibility to ensure that individuals accused of a crime who cannot afford legal representation are provided with a qualified defense, a county spokesperson said on Wednesday. Charlie Kirk, a 31-year-old father of two and Turning Point USA founder, was delivering remarks at Utah Valley University when a sniper's bullet struck him in the neck as he sat in the campus courtyard. Court documents describe Robinson, an electrician apprentice, as someone who had recently distanced himself from his family and grown, quote, more political, expressing support for pro-gay and trans rights. Investigators say he texted his roommate and romantic partner confessing to the killing. Quote, I had enough of his hatred, he allegedly wrote. Some hate can't be negotiated out. Robinson faces aggravated murder charges, which carries the death penalty in Utah. That means both his lead counsel and co-counsel must be qualified for capital cases under state law. Nestor is also representing Corey Richens, the Utah mother accused of fatally poisoning her husband and then writing a children's book about grief. Robinson will return to court on Monday, September 29th. A federal judge announced Thursday he will decide whether to throw out 2 prostitution-related convictions for a former hip-hop mogul or move forward with his sentencing set for next week in Manhattan. Sean Diddy Combs' defense attorney Alexandra Shapiro urged Judge Arun Subramanian to toss out 2 violations of the Mann Act that resulted in convictions, saying the infamous law had racist and sexist origins that are well documented and beyond dispute. Shapiro urged that Combs cannot be held responsible for financing and helping to arrange the transportation domestically and internationally for elaborate sex performances that he frequently filmed over a 15-year period. The 55-year-old was acquitted of sex trafficking and racketeering conspiracy, but convicted in July of arranging interstate travel for prostitution. Prosecutors said Combs paid for and arranged the drug-fueled sexual marathon performances between male sex workers and his girlfriends, some of whom testified about being beaten, kicked, and choked by Combs. Assistant U.S. Attorney Christy Slavic argued that the jury verdict should stand, saying it was in the public interest to prevent prostitution, particularly when it involves the kind of violence and drugs that occurred when Combs was involved. Combs' lawyers also argued in court papers submitted this week that he should be sentenced to 14 months, which would secure his immediate release with good behavior. His lawyers claim he has been sufficiently punished and argued continued incarceration serves no positive goal. Prosecutors argue he should serve years more, although they won't submit their sentencing recommendations to the judge until next week. Judge Subramanian, who has twice denied Combs bail, has signaled he may lean toward a longer prison term. Combs faces up to 20 years in prison, 10 years on each of his 2 convictions. As of the time of this recording, Combs is scheduled for sentencing on Friday, October 3rd. The body of a 14-year-old girl found in the trunk of a popular singer's Tesla earlier this month has been released to her family for memorial services. The Los Angeles County coroner confirmed the release of Celeste Rivas' body on September 23rd, with the funeral scheduled for October 4th. Rivas' relatives addressed the tragedy in a GoFundMe statement, describing her as a beloved daughter, sister, cousin, and friend, and asking for help to cover funeral costs. Her family is heartbroken and devastated by this tragic loss, organizers wrote. Her body was discovered September 8th inside a Tesla registered to the singer David, spelled D4vd, whose real name is David Anthony Burke. Detectives with LAPD's Robbery Homicide Division later executed a search warrant at a Hollywood Hills residence linked to the 20-year-old singer. Quote, several items of evidence were recovered and will be analyzed by detectives in the coming days. This is an ongoing investigation. Investigators are following up on several leads, a representative for the LAPD told reporters. The artist, known for his viral hit Romantic Homicide, has not spoken publicly, though his team has said he is fully cooperating with police. He has since canceled the remainder of his U.S. tour amid the investigation. A trial date has been set for a Texas man accused of murder in connection with the 2024 disappearance of his wife, whose body has not been found. Brad Simpson, accused of murdering Suzanne Simpson, now has a tentative trial date set for February 13, 2026, with a pretrial hearing scheduled for January. At a court hearing Monday, prosecutors and defense attorneys told Judge Joel Perez they were at an acceptable point to proceed with the trial. Prosecutor Casey Sandoval said most evidence from the Texas Rangers and Olmos Park police had been turned over with only a few pending items from the FBI and tip line voicemails. Defense attorney Stephen Gilmore said he was confident that he has everything needed from the DA's office, but less certain about law enforcement. Suzanne Simpson was last seen on October 6, 2024 at a party at Alamo Heights. Investigators said she and her husband had been in a dispute prior to her disappearance. Brad reported her missing the next day, but her remains have never been found. He was charged with murder in November of 2024 and indicted the following month. Simpson's business partner, James Cotter, faces charges for allegedly helping him hide an AK-47 that was illegally modified. Authorities said the firearm was modified into a machine gun that was not correctly registered. Surveillance footage gathered by investigators allegedly showed Brad Simpson driving with 3 large trash bags, a trash can, and a, quote, large bulky item wrapped in a tarp the day after Suzanne's disappearance. An Arizona man accused of killing his 2-year-old daughter by leaving her in a hot car may take the stand in his own defense, according to his attorney. Defense attorney Mark Adair argued that the case against Christopher Scholtes is unusual, noting he has only found one other instance where a parent was prosecuted for first-degree murder in a hot car death. Police say while his daughter Parker was left strapped in her car seat, Scholtes spent more than 3 hours drinking, playing video games, and watching pornography. Adair also requested a psychiatric evaluation for his client, noting family concerns about memory problems. The defense has retained a doctor specializing in cases of guilty except insane, a designation under Arizona law that could lead to psychiatric confinement instead of prison. The child's mother, Erica Scholtes, has not supported the prosecution and was reportedly subpoenaed along with her 2 other children. While Arizona law generally shields spouses from testifying against one another, exceptions apply when the charges involve harm to a spouse or child. Despite rejecting a prior plea deal for second-degree murder, which carried a potential 10 to 25-year sentence, Scholtes' defense is still exploring the possibility of a plea agreement with the help of new evidence he's developed. Judge Kim Ortiz denied a request to delay proceedings, keeping the trial set to begin the end of next month. After an 8-day preliminary hearing, a judge ruled that the case against a California man accused of murdering his wife, whose body has never been found, will move forward to trial. Tyler McCain is charged in connection with the disappearance of his wife, Nikki Chang Say-Lee McCain. On Tuesday, Detective Kylie Holroyd spent the entire day on the stand walking through more than a year of investigative work. Holroyd described interviews with 3 of the couple's daughters. All spoke of abuse they witnessed. One called McCain possessed and said their mother used the 4 children as shields to protect herself from McCain. One daughter described waking up to the sound of a fight and seeing McCain throw her sister to the ground before beating Nikki. As the testimony played out, McCain sat silent, mostly keeping his head down and in his hands. Prosecutors closed by revisiting cell phone records and showing Nikki's phone remained active until May 27th through 28th, nearly 2 weeks after she vanished. The signal first placed the device near McCain's home, then near property where his mother and grandmother lived before it went dark for good. At the conclusion of the hearing, visiting Judge Thomas Bender ruled that there was enough evidence to move forward, and McCain will be arraigned on October 7th. Before we get to what's coming up for next week, I just wanted to take a moment to say thank you. Thank you so much for being a part of this growing community, but I want to give a special shout out to Metellus Rex for their kind words on Apple Podcasts, and to our CC crew members Britt Black and 8 Feathers of Hope for your comments on YouTube. We can't thank you enough for your continued support. Please keep those reviews coming. We appreciate your help in spreading the word about Courtroom Confidential. On the docket for next week, Lindsay Clancy, the Massachusetts woman charged with murdering her 3 young children before attempting to take her own life, will be back in court on Tuesday, September 30th for a scheduling conference. Trial for Ohio woman Bianca Ellis is set to begin on Wednesday, October 1st. Ellis is accused of fatally stabbing 3-year-old Julian Wood in a seemingly random attack in a grocery store parking lot. She faces 10 felony charges for the June 2024 homicide. And finally, please join me this Sunday for a live premiere of our Courtroom Confidential Case Notes Rex Heuermann, a deep dive into the Gilgo Beach serial killer. In this episode, I'm joined by two special guests to cover the decades-long hunt for the killer responsible for the brutal murders of at least 7 women in Long Island, New York. You can join the live chat at 9 a.m. Pacific, noon Eastern on YouTube. And that is it for us this week, folks. I am your host, Josh Ritter. You can find us on social media at CR Confidential on X, at The Courtroom Confidential on Instagram, or at thecourtroomconfidential.com. Thank you again for joining me. Have a great weekend, and I will see you again next week for another episode of Courtroom Confidential.